Hello and welcome back to Series 2 of Calm the Conflict, The Art of Resolution, our podcast all about mediation and resolving disputes through mediation as an alternative through the court process. I'm Zakia and I am a commercial litigation solicitor to businesses, helping them resolve disputes. David?
Hi, thanks. I'm David Goldberg. I am a partner in the disputes team at EMW. I'm also an accredited mediator.
Today, David and I are going to talk about why do businesses still choose court over mediation. I want to sort of find out a little bit more about why that would happen when mediation is something that we believe, both you and I, you as a mediator, me as a lawyer acting for parties, encourages parties to use mediation as a tool to settle disputes with less cost involved and less stress involved. But why then do they still choose to go to court?
I suspect it is the unknown, and it's touchy-feely. The whole thing, mediation historically has been a bit, touchy-feely. Let's see what we can do. What are we going to do? How can we help it out? Can we get this resolved? As opposed to getting on with it. So I think part of the problem is some businesses see actually there's no point wasting time. There's no point wasting money going to a mediation. Let's just get the claim issued. It's a bang to rights claim, and therefore let's just get on with it and issue. That is unfortunately the situation, I think.
Yeah, but I think in my experience dealing with the court service, the delays, taking a case to trial, 78 weeks or something for a fast track case. 18 months and you've still got to do a lot of work because orders are coming through from the court and what parties have to do. The work still has to be done. The lawyer's fees still have to be paid. So why not then try and settle that dispute early on, save all that hassle?
I think it's a mental block thing. People have historically not been comfortable with mediation. If they've not done it, they don't know what it is. It can be slightly scary and you understand there is a system, a court process. But you're absolutely right. They're going to incur more costs going through to court. They've got delays. They're still going to have to do the same work. You're going to have to do the same work running through the process. And therefore you're not saving any money by not going to mediation. And it does just seem sensible to give it a go. I mean, it's not a huge amount of money to mediate. And if it doesn't work, it doesn't work. If it does, fantastic. And sometimes we can narrow the issues as well. So, there might be a issue that one party sees is fantastic or not. If we can get that resolved, that might overcome the block. But as you say, the process takes so long through the courts. Give it a go.
Yeah, but in my experience, again, I'm going to only talk about my experience with parties that want to go to court and not through the mediation process. It's more so to do with, I want to have my day in court. I hear that still. I think over 20 years, I might have stopped hearing that from businesses because I'm dealing mostly with finance directors, CEOs of an organization. So they're not silly,
No, absolutely.
So they know what's involved, and they're very, very, very busy in running a business. So why do you want to have your day in court and not try and settle this, get this off your list, and move on and concentrate on your business?
I agree. Again, there is no logical reason not to do it. It's getting your head in the right space. And it's also often, if you're talking at CFOs and that sort of level, it's all just about the money. It's in the accounts as a debt. They need to be seen to be doing something. Let's get keep it rolling, get the system, and we'll get there at the end. But it's in the business's best interest to get it mediated and get it sorted out sooner rather than later, and not a huge amount of money.
And given that courts now pre-legal, pre-litigation encourage, the court rules, say that parties should try and settle disputes or settle a matter using alternative dispute resolution methods. Is there any time where it's reasonable for a party to say no to mediation?
Yeah, I mean, if a party thinks that they are absolutely slam dunk going to win, then you're not going to convince them to go to mediation. The fact of the matter is there's always a risk in litigation. It's never that straightforward. We've covered this before in previous episodes where something crops up that email turns up. I had a case very recently where two issues in dispute. The client, this is where I was acting for a client as opposed to mediating. The client said, absolutely no. We never agreed that. And in the disclosure, bosh, an email comes in that says that was what was agreed. Egg on face, have to deal with it. If we try to get, and we ended up going to mediation on that one and settling it. But you just don't know. And the case law is pro mediation. Practically, it's sensible. Commercially, it's sensible. That there are no reasons I can't see not to try mediation, but I would say that, wouldn't I?
Yeah, absolutely. Well, as a mediator, yeah. But even just as a litigation solicitor working with businesses, I would encourage them to use mediation as a tool to try and settle the case, because as we've said in our past episodes, it's a great way to save time, to save money, and to save the stress of going to court. So when businesses are thinking about, well, actually, I'm just going to take this straight to court, or Zakia, just issue a claim on this, I will be saying, well, actually, there's a possibility that we could do mediation, and that's something that businesses should really think about.
Absolutely. I mean, I litigate, same as you, when I'm not mediating, I also litigate, and I've got very big things, some small things, some medium-sized things, dealing with FDs, CFOs, and etc. And again, I'm having the same conversation, but from a slightly different perspective, because I'm saying, look, let's get into mediation. I know the process. I won't be mediating, but it's just a good, sensible commercial idea. The people are coming around, I think, in my experience. But you're always going to get people that say no, and as long as they're warned that there are the risks that there's case law, and why not give it a go?
Yeah, absolutely. So just to wrap this up, this particular episode, I mean, any final words for businesses that are listening in to this, that's thinking, actually, I've got a dispute, I want to take it to court. How do you want to wrap it up and say to them, actually, think about mediation? Yeah,
I think just be open-minded. Think outside the box. If you think outside the box, most businesses just want, if they've got something on their books, they need the books cleared. They needed it to be an audit trail to say that we've gone through a process. If they're prepared to make a compromise, and it doesn't have to be a huge compromise, it can be on interest or whatever it is that's available, and costs, whatever. So definitely give it a go. And if try it once.
Yeah, absolutely. And if you don't know enough about mediation and what it involves, then go back and listen to Series 1, episodes 1 to 10, because we go through the day of mediation, preparation for mediation, and we've even got an episode on how to pick a mediator.
Absolutely.
So if you're struggling with any of that and thinking, I want to go to court, reconsider, think about mediation. Thank you so much for listening. We're going to bring you back more episodes, and if you've got any questions, then feel free to drop them to David and I both. All the details are in our links in Spotify, YouTube. You can find our details there. Thank you for listening.
Thanks, everybody.
Thank you for listening. This podcast was brought to you by Right Here Creative, a video creative agency based in Oxfordshire. Check them out at rightherecreative.co.uk.